Good morning. You're James Loftton.
Yes, ma'am.
And it looks like there's a motion to revoke probation in Mr. Lofton's case in cause number 16-2.
Right off the bat, we've got a motion to revoke probation. That's basically the court deciding whether someone blew their second chance. This isn't small stakes probation. Revocation can mean going back behind bars. The judge here wants to move quickly, which tells us they're serious about keeping the docket tight.
4485, and what is the announcement?
Your Honor, the announcement is the state just made us a plea offer is that I believe we're probably going to take that if we could reset it for a date certain to do that, as I need to wrap up a misdemeanor case. He needs to get his affairs in order, which I believe it's an offer of ISF.
Okay. When is the misdemeanor set?
Misdemeanor has just been reset.
Which they'll always move it up if you need to. If there's some issues like this, I don't want to put it off for too long.
No, I'd like to get it done in the next 45 days or something.
Oh, no, it'll be 30.
That's fine.
We're talking 2 or 3 weeks.
Yeah, well, that's fair with me.
What did, when am I not? Do I have a day I'm not here coming up? No. Okay.
I've got a trial in Hardin County the week of the 18th of August.
All right, we're going to reset it to August 4th. That's 2 weeks for a plea on that motion.
Okay.
All right?
Thank you.
We'll see you back then. We'll see you back in 2 weeks, sir. Good morning. You're Alexander Thornton. And Mr. Thornton is charged with fraudulent use or possession of credit or debit cards in cause number 240323. And what is the announcement?
Your Honor, the state just made us a plea offer in that case. Is that we're working on getting back time. Is that we should be able to give the court an answer, and if we could just reset it for the same date that we're setting this other plea, we'll do one thing or another with it. Either put it on trial.
Okay, you're good. All right, because I know you haven't been on this one very long,
No.
but you'll be good in 2 weeks.
Yes.
All right.
One way or another, we'll decide whether
Okay.
we're going to need to be on the trial docket or.
All right, we'll reset it a couple of weeks. Mr. Thornton, stay in touch with Mr. Barrington so you can visit about the case, and then we'll get an announcement at the next. We'll get an announcement at the next court date. You're free to go.
Notice how every case so far hinges on timing, resets, and negotiations. That's the real courtroom grind, not flashy drama, but endless scheduling chess matches. Ever wonder why trials take forever? This is why.
Good morning, sir. You're Dustin Drake. God bless you. And this is 242420. Mr. Lane, what is the announcement?
Your Honor, the court has allowed me at least one announcement. Mr. Drake has been in treatment for many months. He's recently got out of treatment. I've tried to get in touch with him or for us to meet to go over discovery. However, I've sent a really good mitigation packet. It's not really our intention to go to trial to Mr. Nichols last week about his recovery and all. So I'm hoping that maybe if you allow me one more announcement, we can work it out.
All right, so this will be the last announcement. Get with Mr. Nichols. Mr. Drake, make sure you stay in touch with Mr. Lane. So once he visits with Mr. Nichols, you'll know what your options are, and we'll get an announcement. It'll either plea or it will be going to the trial docket at the next hearing, okay? You're free to go. Thank you, sir. Thank you, Mr. Lane. Good morning. You're Gustavo Vasquez. All right, so we reset the case last week for sentencing on Mr. Vasquez's case. I have now myself made a phone call to Officer Clark at the Port Arthur Police Department last week. I think it was on Wednesday, and have not heard back. So that obviously leads me to believe that there is an issue if he's not calling the defendants back, but kind of feel like if a district judge...
Pause. For a second, did you catch that? A district judge personally called an officer and didn't get a call back. In the legal world, that's like leaving the president on read. The judge is clearly annoyed, and that frustration is about to shape the outcome for Mr. Vasquez.
Calls you should call them back. So that I don't disagree that Mr. Vasquez, could possibly have done more, but I also don't disagree, and it sounds like even probation has seen evidence that Mr. Vasquez has tried to do what he's supposed to do. And so based on that, I find it hard to revoke a probation when it looks like he's trying. Today, what I'm going to do after docket, since I have not received that call back, is talk to Chief over there about what is going on, because it sounds like this is not the only case where there's some issues. I also know that I think Jody tried to call, correct, and also gave an email address, and did not get a response either from probation from this Officer Clark. So that being said, what I'm inclined to do, because that is really the primary allegation, is continue the probation and have Mr. Vasquez continue to try, obviously, to register, but potentially maybe go on a higher caseload so that he has to report more. If we can't get that done for some amount of time, at least he'll be reporting to you more often and things like that. Is there anything else that you can think of that would be appropriate at this point? We're about to talk also about treatment and some stuff like that. Okay, so Mr. Vasquez, obviously there's an issue with the reporting, but I still have some concerns because Dr. Asteris mentioned that your progress is below average and needs improvement, and that is not going to...
Here's the twist. The judge just found Mr. Vasquez technically guilty, but instead of revoking probation, she's giving him another shot. That's huge. Judges don't always pull back once guilt is on record. She's balancing accountability with fairness and maybe even sending a message to probation officers dropping the ball.
Be acceptable after today. Do you understand? So you're going to do everything you're supposed to. You're going to continue to try to report, but I mean, regardless, or register, but regardless of that, you're going to do everything else on probation as well as possible. And below average and needs improvement is not going to be acceptable. It's just not. So you're going to, what I'm going to do is, again, find that you entered your plea of true to count 2 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that. I'm going to continue that probation. You're going to be moved to a different caseload where you have to report more often, at least for some amount of time until all of this gets worked out, okay? The concerns that I have are with you, and then I have just as big concern with what's going on over there, because these are cases where obviously we need to know where everybody is, and if we don't have someone taking care of that in that office, then I think the community is at risk over there. And so I'm gonna work on that separately. Let's see, was there any, I made a note of something else. All right, that's really it, just the all right, so you need to make sure you attend every appointment with Dr. Asteris, follow through with everything you're supposed to, engage in that, whether you think you need it or not, you're ordered to do it. And so just going and showing up and doing the minimum amount of work is not going to work, because if you don't complete that in an appropriate way, it's a violation of your probation, okay? All right.
I'd like to say, Judge, just you need to continue to try to register.
Yes.
And keep notes of when you call and what happens, and report that to the probation officer, because she can try to help you. And that way she knows you're doing what you're trying to do what you're supposed to do, okay?
I would say call every week until we get it worked out, and you are every single week. Leave a message. If he doesn't answer, don't just hang up. Leave a message with your name, what you're trying to do, and then that way there's some records, and you write down every time you do that. Again, just like Mr. Parker said, let your probation officer know, and we'll hopefully get all that worked out. Okay? All right. Y'all are free to go. Thank you. Morning. Are you Mark Hebert?
Yes, ma'am.
And will Mr. Hebert waive the formal reading of the indictment?
Will, Your Honor.
Mr. Hebert, in cause number 250455, you're charged with the third-degree felony offense of driving while intoxicated, third or more, from April 16th of 2024. The indictment alleges you were previously convicted of driving while intoxicated March 31st of 2010, and then after that, January 8th of 2013. And how do you plead to that charge? And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with?
Speak up, yes.
Yes, I'm sorry.
And I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you reached is for a 5-year term in prison.
5 years in prison, probated down to probation. Translation: he's convicted, but instead of serving hard time, he'll serve it on the outside, under strict conditions. This is the classic carrot and stick, freedom, But one slip up and those 5 years come crashing down.
But that would be probated for 5 years. You'd be on probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Also, it looks like there would be a dismissal,
Misdemeanor.
a misdemeanor, what kind of case?
It's a harassment.
Okay.
I actually have the cause number now.
Judge, if I may hold off on that until sentencing, just so we
Sure.
can check it.
Right.
Yes, sir. Yes, ma'am. Is that your understanding of the agreement?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number
No
one.
objection.
It's admitted. Is there any evidence that Mr. Hebert's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you at sentencing.
Thank you.
Good morning. Are you John Van Wright? And it looks like there is an MTRP as well as a new case in cause number 242485 and 15-23582. And what is the announcement?
Judge, I'm asking for 30 days only because there's a video that is not formatted correctly, and I'm trying to watch it, and according to the state, it's a pertinent video that I really need to see.
Okay. I'm going to reset it. Make sure you work on that early so that we're not figuring that out on the day of court.
I am, Judge.
Mr. Van Wright, if you'll stay in touch with Mr. Mitchell, once he gets all that worked out, the technology part, you can go in, watch that with him. That way you'll be better equipped to make an announcement at the next court date.
And if I have to, Judge, I'll get Mr. Smith to go watch it in his office if I need to.
Okay, perfect. Thank you. All right, thank you. Morning. Are you Alexis Bourgeois Cooper? And will your client waive the formal reading of the indictment?
She will.
All right, Ms. Bourgeois Cooper, in cause number 241296, you're charged with the state jail felony offense of theft of property from April 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 12 months in the state jail prison, which means you're leaving your punishment up to me. I can give you 12 months in the state jail prison. I can give you less. I can give you probation. It all depends on the information I get when we come back for sentencing. You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they found you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and you're leaving it up to me. Do you understand? And as long as I don't give you more than 12 months in state jail prison, you're waiving any right to appeal. You understand that as well. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Ms. Bourgeois Cooper is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get probation to do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lane. He'll present it to me on your behalf when we come back. And as you're leaving the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you.
All right, this is cause number 24 DCCR 0094. And for the record, Mr. Gertz is joining us via Zoom. And sir, you are Austin Jones?
Yes, Your Honor.
And Mr. Jones is also joining us via Zoom. The case is set for trial to begin with jury selection next Monday afternoon. It is the only case left on the docket, so it will be the number one case for trial next week. Mr. Gertz filed a motion to quash the indictment, so I wanted to go through that so everybody knows where we are for next week. Mr. Gertz, I want to ask, it appears you're asking, it says you're asking the court to excise the defective portions. If you'll explain what you're specifically asking for and what you think is inappropriate.
Sure, Judge. So as you know, aggravated assault of this nature, where it pleads serious bodily injury, allows the prosecution to plead intentional conduct, knowing conduct, and then reckless conduct. In this instance, the problem is the reckless portion of the indictment is not matched with appropriate language specifying the nature of the recklessness as required under the statute, under Article 21.15. And so I guess our request is either A, that the state be required to plead with more specificity what it is that they think is reckless, or alternatively, the reckless portion be struck from the indictment going forward such that they can only proceed on intentional and knowing conduct.
Mr. Hoffpower?
Your Honor, we're tracking the statute. This is how we file all aggravated assaults. They all have, those are in the statute, the three.
Can y'all hear Mr. Hoffpower?
Am I speaking loud enough?
There's the.
I can hear him fine, Judge.
Okay.
Knowingly, I mean, this is part.
I can hear him fine.
The statute of aggravated assault, it always has knowingly, intentionally, knowingly, or recklessly. I'm not sure why, in this particular case, we need to excise that. I mean, that's always how we file that, and it's tracking the statute.
So, from
I'm
my
sure.
reading of the indictment, and we're all obviously making assumptions, isn't something that we should do, but I would think that the reckless, to me, it would read, that any of those, intentional, knowing, or recklessly, that the action of those is the shaking with the defendant's hands. So how is that not specific enough? I guess my question, Mr. Gertz.
The answer is, Judge, this case that I cited in my my motion, State versus Rodriguez, requires the state to provide the acts and circumstances surrounding the allegations that the state intends to prove were reckless. And it goes on to give an example of saying recklessly discharging a firearm by pulling the trigger on a firearm which contained ammunition and was operable is not sufficient. That kind of language that just says that essentially an injury was caused by this mechanism is not sufficient to describe why it's reckless. What's the gross deviation from the standard of care that an ordinary person would normally apply here that he has knowledge of? And that's just not contained in the pleading.
I'll respond quick.
Now we're in legal nitty-gritty. The defense argues the indictment isn't specific enough about recklessness. Sounds technical, but it's huge if an indictment is too vague. A whole case can crumble before trial. The judge here says, nope, the wording holds up. That means trial is still full steam ahead.
Yeah.
And I'm not sure about this particular case, but I have had one of these before in regards to reckless deadly conduct where you understand, like, there's a felony and a misdemeanor, and recklessness is a part of that particular charge, which makes it whether or not, whether it's a felony or whether it's a misdemeanor. But to my knowledge, there's not analogous to what we're talking about in our case, which is an aggravated assault, the deadly weapon, in which we do get I think we pled the case sufficiently.
I think if it had, so I'm looking at Article 2115, which obviously says that it must specifically have to do with this one, recklessness and criminal negligence, that the act or acts relied upon to constitute recklessness must be alleged. I'm going to deny the motion to quash. I believe the indictment alleges sufficiently the acts of shaking with defendant's hands as the potential or alleged reckless or intentional or knowing. But I think there's enough specificity for the defense to know what is alleged that his client either did or omitted from doing with regard to the recklessness. So I am going to deny that motion. Is there anything else that you guys know of that we need to kind of be prepared for before jury selection on Monday with regard to any other pretrial issues?
No, Judge, as far as I'm concerned, that was my only issue.
Okay, so we will, if anything comes up, just y'all know how to get in touch with me. Let me know. We can take care of it either. If it has to be taken care of before board hour, we'll do it. If not, we'll do it that afternoon after we go through jury selection. All right, so we'll see y'all back here.
And Judge, just so you know, I may raise this issue again as the trial progresses. I just needed to preserve it 10 days in advance under the statute. And so I understand the court's ruling, but depending on what the evidence is, et cetera, I may raise it again.
Okay.
Because I anticipate what's going to happen, Judge, is that the experts for the state are going to try to allege intentional conduct. And again, part of the problem with this statute is it allows them to do all three. And so I'm just letting the court know that I'm going to be likely raising it again, depending on what the evidence is. So.
Okay. We'll take that up at the appropriate time if it happens. Mr. Gertz,
I appreciate it. Thank you, Judge.
Would you have your office send an order over for me to, for that motion to quash? They did. Never mind. They already did.
I'm sorry, that's not.
Okay.
All right. Thank you both. You're excused, Mr. Jones and Mr. Gertz. See you next week.
Thank you, Judge. We'll see you Monday. Thank you.